So as the Insolvency Bankruptcy Code is the code for the stressed assets of the banks, usually whatever are the stressed assets in the market, which are like Section 7, the financial creditors, if they have any debt due to them, and Section 9, operational creditors, any of their claim or debt is due to them, is not paid by the company, and even the company by itself, Section 10, they can go for insolvency. So in Insolvency Bankruptcy Code, the object of the code is to, there are four objects of the code. One is resolution of the corporate debtor and maximization of value to all the creditors, and balancing the interest of all the creditors. Sorry, just 1 minute. Give me a minute. Okay. The objects of IBC is to consolidate and amend the laws, existing insolvency laws, and promote entrepreneurship and maximize asset value and ensure time-bound resolution process of insolvency cases and maximization of value for all the stakeholders. If we see the object of the code, one of the objects is maximize asset value and ensure time-bound resolution process and balancing all the interest of all the stakeholders. See, when we see the object maximize the value of the asset during the resolution, one of the to attain one of the objects of IBC, earlier when the code was notified and the resolution and the regulations were notified, during the process of IBC, during the process of resolution, there were a lot of issues which the market has faced. That is, whether the promoters of the company, whether they can come back entry and they submit the resolution to the company and they take control of the company. So one of the main key factor of IBC is creditor possession of the company. So once it is creditor possession of the company, then the promoter loses the control. So once the promoter loses the control, the object of the code will be achieved through effective way. That was the main, even the BLRC committee report and even the object of the code. So to plug this issue, to plug what the market was facing through the backdoor entry of the promoters, the section 29A was notified. So what is the main object through amendment? This section 29A is notified. This rationale is to keep the creditors in control of resolution process and to plug the promoters who have contributed in various ways to for the deterioration of the stressed corporate debtor by putting huge credits of banks and financial institutions at risk. This contribution of stress by the promoters was minuscule compared to the size of the debt, because the creditors and the larger market stakeholders were suffering because of the stress. So once we see what is the object of section 29A, the main object of introduction of section 29A was, this was inserted through an amendment in ordinance in 2017, which again later became an amendment in 2018. This is a critical amendment which came into effect from November 23, 2017. This has mainly addressed a critical loophole. So there were significant lacunae and absence of specific criteria of disqualification of persons who are submitting the bid, because of which there was a lot of issues which have cropped up before NCLT, and many issues are taken up by the NCLT, and many applications were filed for seeking clarification. So this has, because there were no specific, there was a loophole, there was no specific criteria disqualifying people for submission of EOI. This led to a trend in the market where promoters who had defaulted on the loans, and they were attempting to regain the control of the assets, the same assets. Then at undervalued prices, the promoters were coming to market at a significantly undervalued prices. So this was mostly the buyback their own companies for a very minuscule amount through backdoor entry. So here the section 29A object for which this amendment has come is, the core principle behind this was clean hands doctrine. So the fundamental principle which drives section 29A is the clean hands doctrine, which asserts that individuals or entities who are responsible for the financial distress of this corporate debtor with a history of financial misconduct, they should not be allowed and they should not be benefited from this resolution process. So that this section ensures that the integrity of IBC in CIRP process, or even the liquidation process, the clean hands doctrine, because of this, the section 29 was promulgated. And the section 29A is a deterrent where only punitive and measures are imposed, ensuring that resolution process leads to genuine value maximization for creditors, so that the distressed asset, whatever the value is left, is handed over to a capable, ethical, and financially sound management team. So the section 29A provides an exhaustive list of categories where a person is ineligible to submit a resolution plan. So basically, once we come back to this section 29A, can you go back? So section 29A lays down the ineligibility to be a resolution applicant. So what happens in the CIRP process? There are processes under IBC through which the stressed asset will be resolved. One is through CRP process, or liquidation, or pre-pack, or fresh start process. So across all these, section 29A is applicable. In CIRP process, expression of interest will be issued by the resolution professional, and the persons who submit the expression of interest should not attract any ineligibility under section 29A. And the role is, the responsibility is on RP to do the due diligence of the prospective resolution applicants. At EOI stage, a preliminary diligence is sufficient, but at the time of resolution plan, RP has to do a detailed due diligence, ascertaining whether the prospective resolution applicant who is submitting the plan is an eligible applicant. And when it comes to liquidation, there are two things. One is under section 230. The liquidation will be through section 230, a scheme of arrangement, or through a auction process. So in any of the process, either section 230 or auction process, the applicant should be a compliant of section 29A. No ineligible applicant is allowed to submit even section 230 scheme or participate in the auction process. And in pre-pack, it is an pre-pack is excluded. So, but pre-pack, again, I'll discuss in detail. Again, when this section 29A is applicable to across to all the applicants except MSMEs. MSME, the existing promoters, if the corporate debtor is an MSME, he can submit a resolution plan. But however, under section 240A, which was introduced, for MSMEs also, there is an exception. All the section 29A clauses are applicable except clause number C and clause number H. So we have to be very clear, even for the MSME, when the RP or the liquidator is doing a diligence, they have to ensure that section 29A is complied, except C and H are not applicable. So when we go very detailed into section 29A, who are the persons who are ineligible to be a resolution applicant? One is an undischarged insolvent. Undischarged insolvent means there should be a court order, and the court order need to specify the person as insolvent. So we will go very detailed each clause by clause. So undischarged insolvent. Usually after the personal guarantors sections are notified, the part 3 is notified. When the companies are undergoing CIRP or liquidation, they are submitting the EOI, or when they are participating in liquidation tenders, undischarged insolvency professionals have to be very clear whether the personal guarantor, suppose if he is an MSME promoter, he is submitting a resolution plan, expression of interest for the corporate debtor. At that time, you have to ensure whether the personal insolvency resolution process is running against them and the process is still under adjudication, or still the personal guarantor is yet to submit the repayment plan. He is not undischarged insolvent. If the process is running, if the process is running for bankruptcy trustee also, he is not an undischarged insolvent. So we have to ensure to be a person to qualify to be ineligible. Undischarged insolvent means there should be a court order. And clause B, a person is a willful defaulter as per guidelines. As per RBI guidelines. So willful defaulter list is always published by RBI, and that from that list the RP or liquidator can verify whether that person's name is there in that willful defaulter. Then coming to clause C, have an account classified as non-performing asset for more than 1 year and have not repaid the overdue amounts before submitting the plan. So in this case, the resolution applicant company or the resolution applicant is an individual whose account is classified as an NPA for more than 1 year. So this underlying is for more than 1 year and have not repaid the overdue amounts before submitting the plan. So we will see 3 consequences here. One is a person is classified as non-performing asset. Less than 1 year, he will be qualified to submit the EOI. If he is qualified as NPA for more than 1 year, see, first clause is 3 things we have to interpret here. One is NPA less than 1 year, NPA for more than 1 year, and third one is 1 year and have not repaid the overdue amounts, and fourth one is he has repaid the overdue before submitting the plan. So in all these 4 things, in 2 things he is disqualified and 2 things he will be qualified. One is if an NPA is declared not more than 1 year, he will be qualified to submit the EOI. For more than 1 year, he is disqualified. And he has not repaid the overdue. Then also he is disqualified to submit the expression of interest. Then clause number D, have been convicted of an offense punishable with imprisonment of 2 years or more in the last 2 years under specified laws. So here if you see, a person should have been convicted, not that any prosecution is going against him or it is still under adjudication. They can submit the EOI, but however, if he is convicted of an offense, that too punishable with an imprisonment of 2 years or more only, and that too in the last 2 years. If you read the regulation, it is very clear that convicted for 2 years and in the last 2 years under specified laws. Then clause E is disqualified to act as director under the Companies Act. So disqualification under Companies Act, various provisions, if he is disqualified and there is an order from ROC or suppose in non-filing of financials also the director gets disqualified. In that case also the director or the director is disqualified to submit an EOI. And prohibited by SEBI from accessing the securities market or trading in securities. Again here there should be an order from SEBI against that person from accessing the securities market. Then that person is also disqualified to submit an EOI. And have been involved in managing a company where PUFE applications have taken place and a court order has been passed against them. Suppose a PUFE application is filed in NCLT, but there are no orders and the person want to submit an EOI. It is allowed. He is eligible because there is no court order against that application. So if there is any PUFE application and there are any specific orders against that person, then he is ineligible to submit the EOI. Then clause H is a connected person such as promoter, holding company or related party of someone who is ineligible under the above clauses. So in related to the above, if he is a connected person, again connected person definition, we have to go back to the Companies Act here. The connected person should be a promoter or holding company or a related party who is, if connected person of the above any undischarged insolvent is submitting a plan. If that person is submitting a plan and he has a connected person who's against whom there is a PUFE order or against whom SEBI has passed an order prohibiting, or that person is a disqualified under Companies Act, then also that person is ineligible to submit a EOI, expression of interest in CIRP, or participate in auction or section 230. And clause I, have given a bank guarantee for a corporate debtors loan that has been invoked and remains unpaid. So there has been an invocation of bank guarantee and that has not been paid. Suppose a person against a personal guarantor, a bank guarantee is invoked and that guarantor has not yet paid the amount. The amount is unpaid. That person is also ineligible to submit a resolution plan or participate in liquidation, auction or section 230. So when we see section 29A, it is restrictive in nature. It restricts access to the resolution process so that only responsible and the genuine participation from the market. And it is negative in nature. It prohibits certain category of persons like willful defaulters, connected persons, or defaulting promoters, or who are banned by SEBI. Those category of persons are not responsible to participate in the IBC proceedings through CIRP or liquidation. Then section 29A is a disqualificatory. It disqualifies persons, entities from participation in the bidding process. It is preventive and protective. It also protects the sanctity of the resolution process by excluding undesirable people who have contributed to the stress of the company or stress in the market. We'll go to the next one. So this section 29A serves as a deterrent, and primary purpose is to ensure that it leads to genuine value maximization to the creditors, and the corporate data is handed over to the sound management, financially, ethically, to the team of successful resolution applicant or the successful bidder. So section 29A is very exhaustive, where we have to ensure as an RP or liquidator, we have to ensure the basic diligence can be done while submitting the plan or submitting the documents. Usually an affidavit is also taken from the expression from the prospective resolution applicants or the bidders about their qualification, that they are not ineligible to submit to participate in the process. Where it can be exhaustive, the affidavit can be exhaustive, where you can give the details of the connected persons, or when the expression of interest is given, detailed expression of interest will have all the formats. So currently in market, the detailed EOI formats of the affidavit all mostly formalized. So very detailedly exhaustive list of section 29A, the prospective resolution applicant or bidders, connected persons, related party list is also provided to them, wherein they'll fill all these details and give. And RP, if he has a good supporting team, they can in-house do the diligence, or otherwise RP and liquidator can appoint a third party from market who will do a very detailed diligence. Usually the outsourcing in some, it depends again from fact to fact, from case to case basis. RP or liquidator can take a call. If diligence, if there are more expression of interest and the parties are big, and there are some apprehensions that there could be related parties, that time RP or liquidator can take help from market players. There are many players who are giving section 29A exhaustive reports, where we can have proper diligence online, even offline. Various sources they will verify, like RBI, CIBIL, then NCA. IBBI is also one of the good portal from where we can get the details whether the company is under CIRP or liquidation. So these are the few basic checkpoints where RP can start his diligence, RP or liquidator. So again, undischarged insolvent willful defaulter. Again, when we go to the willful defaulter, there are RBI guidelines. For at least 1 year, they'll publish this NPA details. So the disqualification ceases if a person pays all the overdue amounts, and they'll regularize. So basically, CIBIL will be a checkpoint for this willful defaulter. Then undischarged insolvent also, mostly what the market will do is they'll try to do some online searches where they can get some court orders. So basically, the conviction for 2 years under various economic offenses or criminal conduct. So mostly when we were discussing this, we didn't discuss in detail. So for the conviction, the person should have been punished for 2 years. Mostly it is economic offenses or any criminal conduct also. So I have one example. In one of our case, the promoter was barred by SEBI. There was an order from SEBI disqualifying him to be a director on the of any of the SEBI registered intermediaries, and also not to participate any in the market, and to be a director on any market intermediaries. So that person, there was a specific order, but this order was challenged. So this order was challenged. He says this is challenged. But we have to consider as on date of submission of plan whether the disorder is in place, and there is, even if it is challenged, there should be an order in the appropriate forum like appellate authority, or wherever the promoter is challenging, there should be a specific order. So if there is no order, RP has to see whether the disqualification continues. So when we come to avoidance transactions that we have clearly, I have explained. So when it comes to the connected persons, this is more critical for an RP. When we are doing the diligence of the connected persons, this is the most litigated and very crucial clause. So this is called as anti-proxy clause. Usually this in IBC market, people call this as anti-proxy clause, because here the disqualification is not only extending to the person who is submitting, but also to the persons who are acting jointly or in concert with the person who is submitting, like who may be a promoter or in the management or control of the resolution proposed resolution applicant, and who is also a related party of the resolution applicant. So this prevents use of family members, trusts, or any closely associated entities or persons who can submit the resolution plan. So here I would like to share one or two experience. In few cases, we get the expression of interest through consortium of people. So we get like two or three jointly companies coming, or two or three companies along with one LLP or one individual, they will come and submit the plan. So at that time, we are supposed to do the diligence of all the connected persons. Suppose consortium consists of four companies. So we have to do the diligence of four companies, along with that four companies who are the directors. So, and there are four layers. So I'll in next few slides, I'll explain how these four layers RP or liquidator has to examine the connected persons. So whoever is connected or whoever is disqualified, who has indirect control, they are also disqualified to submit the expression of interest. So I'll just go through a few important aspects of Section 29A. There are many landmark orders in regard to the Section 29A, because the purpose of Section 29A is the Section 29A acts as a deterrence against reckless conduct and of the promoters who want to come through backdoor entry and again create stress in the market through their mismanagement. Already they have mismanaged this company, and high risk is involved. Then upholding public confidence in financial system, and again preventing recurrence of defaults. So when we see Section 29A is one such clause, then comes regulation. Uh, I also want to touch upon one important point of ineligibility in foreign jurisdictions. This is 29A I. So what Section 29A I reads is, can you share that clause? I'll read out. I'll read for the benefit of the participants. Can we share section 29 here? Yeah. So if you read section 29A I, it says, go down. Yeah, it's here only. Is subject to any disability corresponding to clauses A to H under any law in jurisdiction outside India. So a person is ineligible to submit expression of interest or participate in the CIRP process or liquidation process if he has any disability corresponding to A to H. A to H is again regarding if he is any undischarged insolvent or he is any willful defaulter in other country and he has an NPA or convicted for any offense punishable for any criminal or economic offenses or disqualified to act as an director or involved any PUFE transactions, etc. And who all these are applicable to a person who has disability under above clauses in a jurisdiction outside India. Suppose if any person is submitting an expression of interest from any outside India. So we need to, we are not experts in ascertaining whether that person is qualified or not. He will give declaration, he will give affidavit. But what we can do is we have to seek opinion from the foreign professionals in that country, whether this person who has submitted expression of interest for participation in resolution process or liquidation has any disqualification. This is one important point I wanted to cover. Then when the corresponding that we have CIRP regulations, regulation 36A, 4 and 8, where it says it has a reference to section 29A. A detailed EOI to state the ineligibility norms under section 29A to the extent applicable for prospective resolution applicants. So when RP or the liquidator issues an expression of interest or gives a tender document, the auction document, a detailed document, he has to clearly specify what are the ineligibility norms for participation. So this is an important regulation. When expression of interest is issued, detailed document is also issued. There, mandatorily, we have to ensure that ineligibility norms are provided. And also we need to provide the details of corporate debtors registration status as MSME. And in the expression of interest document also, we need to ask the applicant whether they are MSME. Then RP also conducted due diligence based on the material on record in order to satisfy that PRA complies with applicable provisions of section 29A. So here under regulation, the duty is on RP that RP has to conduct a due diligence based on the material record available to him. This again gives a very, one of the key functions of RP is take over the company, run the process, ensure the timelines are followed as per the prescribed timelines, and issue expression of interest and ensure that only proper persons are getting into the expression of interest. So RP during CIRP process issues a prospective resolution applicant and final resolution applicants list. So that time also we need to ensure while issuing the prospective resolution, before issuing prospective resolution applicant, RP has to do a basic diligence based on the information available and issue the prospective resolution applicants list. And even in liquidation also, liquidator has to ensure that only the Section 29A compliant parties are participating in the liquidation process. And multiple roles of RP. There are various provisions where Section 29A is significant. While participating in the process, and even when we come to Form H also very important form, where the NCLT, while evaluating your application for approval of resolution plan, it will go through very detailedly, minutely your Form H. So basically, in when I am attending the resolution plan approval applications before NCLT, they will ask 2-3 important things. One is whether you have Section 29A compliance. Have you done the diligence? And they will ask, there is a format prescribed where the RA has to give his Section 29A compliance certificate. So along with the resolution plan approval application, you will file this mandatory attachment. So NCLT will go through this. Then comes whether the required percentage voting we got, and whether feasibility, viability, COC has approved this resolution plan. And third thing, the NCLT will ask whether there is a proper monitoring mechanism in place for implementation of the plan. So usually in across all benches, usually this is a standard. Mostly the NCLTs will not go much detail if RP gives a clear clarification in Form H. So very important key aspect of Section 29A is very critical duty of RP and liquidator, so that no person who is disqualified or ineligible gets into the process through for resolution or in tender participation. So we'll just briefly touch on liquidator's role. In under Section 35(1)(f), the liquidator shall not sell the asset of the corporate debtor to anyone who is ineligible to present the resolution plan. The ineligibility also extends for compromises under Section 230 of the Companies Act, or even the sale as a going concern, or even the e-auction. So it closes all the routes for the promoters to be involved in the resolution of the corporate debtor, except the MSME. Again, MSME only 2 clauses not applicable. All other clauses are applicable to MSME promoters also. The RP and liquidator has to ensure and keep this as an important point in focus. One is section, even when a person is ineligible to submit a resolution plan and he is disqualified, but that person wants to come and submit Section 230 compromise arrangement, or he wants to participate in liquidation, then he is ineligible. That is what Section 35(1)(f) clearly states. Again, there is a regulation which says no movable asset, immovable asset, or not readily realizable assets or actionable claims can be sold to a person who is ineligible to be a resolution applicant. This is as per liquidation regulations. So when we discuss this, I just want to touch on one case in SBI versus Anuj Bajpai, liquidator. Here, it has come to the notice of liquidator. One secured creditor wanted to sell the assets to a person who are ineligible under Section 29A. So I just want to bring brief points here. Usually in liquidation, when the secured creditors submit their claim, there is a column in the claims form. One is, as per the section, either they can relinquish their security to the liquidation estate, again that assets, whatever the secured creditor has charged, will come to the liquidation estate. Or otherwise, secured creditors can keep the security with them, and they can pursue this outside liquidation. They can sell this independently. So in this case, what has happened? The secured creditor was trying to sell the assets of the corporate debtor to a person who is ineligible under Section 29A. So liquidator can always object saying that the participation in liquidation by any person who is ineligible to submit a resolution plan is also ineligible to acquire the assets here. Here the NCLT has rejected the application under section 52(1)(b) read with section 52(2) and 3. If during liquidation process assets, if secured creditor want to sell who is ineligible under section 20A, 29A, the provision is also applicable during liquidation and to liquidator also. Even if secured creditor want to opt out of section 43 to realize the claim in terms of another section, that is section 52. So even secured creditor want to be out of liquidation estate and he want to sell, he cannot sell to the ineligible persons who are disqualified under section 29A. So when we see recently the Bhushan Steel case also, the Supreme Court has clearly laid down that section 29A is very significant function of RP. So now I'll discuss just very few like layers how RP has to verify diligence of ineligibility. 4 layers. First is we will check the resolution applicant himself. Suppose company A is applying as for expression of interest. You will see the first layer, that company A, whether they are eligible. Then you have to apply all these points. A, B, C, D, E, F, G, H, I, J, section 29A, whether it is applicable, whether they are getting disqualified here. Then second layer is connected persons. You will see the connected persons of the resolution applicant. Suppose company A is there. Who are the connected persons? So there is a section. Can you go to section 524? The related party and connected persons, they are all defined. So we have to go through the definitions given under respective act. That is, we have the connected person and the related party definition under IBC and Companies Act. What is section 524? It is there, related party. 5 clause, section 5, subclause 24. So second layer is connected persons. Third layer is related party of a connected person of RA. So first layer is RA. Next layer is connected person of the RA. Third layer is again that connected person's related party. Then fourth layer is persons who are acting jointly in concert with the person suffering from first layer, second layer, third layer. See, here I would like to give one example. First layer is company A. Then second layer is connected person of resolution applicant. Suppose person B is connected person. And third layer is related party of connected person. B is a connected person. Then C is a related party of connected person. And fourth layer person is who is acting jointly in concert with a person suffering from 3 layers. So here A, B, C is a related party of B. Then again fourth layer is again if we have some other person who is company D, company ABC Limited. That fourth layer person, suppose A is related to the ABC Limited, B is related to ABC Limited, C is related to ABC Limited. Then ABC Limited is again coming under fourth layer. So all this we have to verify. Mostly online tools are available. You can take MCA report. Now we have probe reports where you can get all these details. If you put the person's DIN number, PAN number, SIN number. So these kind of layer reports will come. So these 4 layers also need to be verified for determining the disqualification. So due to extensive litigation and ambiguity in definitions, the section 29A remains again one of the most litigated issues. There are many issues which are coming for litigation. But however, Supreme Court has clarified in three cases, Swiss Ribbons, ArcelorMittal, and also in one more case, we'll take it up. The main important principles which Supreme Court has clarified is Swiss Ribbons and ArcelorMittal and Monet Ispat. So these are important case laws where Supreme Court has dwelled very in detail on Section 29A, and they have given the main principles on which the Section 29A can be applied. See, when we see section 29A, it is again fact intensive nature. So when we are, when RP or liquidator is verifying on this, we have to go by facts. We have to go by facts whether the persons are acting jointly or in concert, related persons or related persons. So each case is again different. There may be simple direct relation or sometimes complex corporate structures are there for connected persons. So all these can be, the diligence can be done by the RP through their support team, or he or she can take help from the market who provide the section 29A reports. So again, the word control, see, if you go to section 29A, here we have the one of the important point is who is controlling connected persons. When we see the important section 29A I, connected persons control, all these are little uh, tricky issues where RP and liquidator has to focus more, like certain joint venture agreements or board seats, like sometimes global holding structures, all these, some investment in subsidiary companies, a holding company, subsidiary company, associate company, all these complex issues we have to structure properly and do the diligence. So we will go to the few judicial precedents. So we have covered few, what is the importance aspect of section 29A, and we have dwelled upon section 29A, various are covered under 29A ineligible, and how the ineligibility and disqualification has to be ascertained based on the provision requirements, and how in during the CRP or liquidation, how RP or liquidator has to do the diligence and how he has to ascertain the connected persons or the disqualification of the corporates, group companies, joint ventures. So it's like a cobweb where you have to try to pull the strings and try to assess the disqualification based on the relation, that is based on the facts. So far any questions or any thing which is not clear?
When, hello.
Yes,
Good,
sir.
good afternoon. This when the bidder enters into this liquidation for bidding, at what point his eligibility is to be seen? Is it when the bid is proposed or when the bid is finalized?
Sir, not when the bid is finalized. So there is, when we issue the tender notice, when we issue for the calling for the expression of interest in participation of the tender, the auction notice is issued. In liquidation, I will just come to the process. One is Section 230, sir. Section 230 is compromise or arrangement. So within 90 days, either the creditors or the shareholders of the company can propose a scheme of arrangement. So that time, when the person is giving an expression of interest that I am interested to submit the scheme,
Okay.
by proposing, he will submit the application and the along with the application, some scheme, if he is supposed to submit any EMD or the requisite documents, that time immediately before participation in the scheme, before meetings are convened or before application is moved to NCLT, the qualification, the ineligibility has to be assessed. Actually, it has to be assessed, sir.
So bid scrutiny is to be at the time of scrutiny of the bids.
Yes, at the time of scrutiny of the bids. That is under Section 230. Then again, when it comes to the auction process or sale as a going concern process, when the person submit the expression of interest, they submit the tender documents. The auction, whatever the auction process document we issue, there will specify all the documents to be submitted by the person. Along with that, some EMD is also proposed. And dates schedule is prescribed in that process document. So there only we will give section, see, as per the provision, if you see, we have covered, we have mentioned that the detailed EOI has to specify the ineligibility norms. That means even under liquidation also, when the process document, we will specify the ineligibility norms. So when the person is submitting itself, he has to assess himself whether he is eligible or ineligible for participation. So if he knows that I am ineligible also, he submits, then we will, when we come and when we find out, then he is not allowed to participate in the process further. At the application stage itself, we are prescribing ineligibility norms. So when in the application, he will submit the affidavit and all.
Same way, when the resolution plan is submitted, the way we are scrutinizing, it has to be done at the submission of bidding stage.
Correct, sir. You are right. Right. Even in CIRP, sir, before submitting plan, there is a process called expression of interest process.
RFRP.
Sir,
No.
issue Form G, sir.
Form G.
We issue Form G along with that expression of interest form. We issue detailed EOI also. That is detailed expression of interest, where we'll give all the formats, eligibility criteria. So under that eligibility criteria, we have financial criteria. We will prescribe some net worth, or we will prescribe some financial criteria. Like if company, suppose big company, we'll ask them their net worth details or capital details, or their last 2-3 years profit details. Some we'll put some turnover of 100 crores example based on each corporate data. Then next is, we'll also prescribe this section 29A eligibility also. So like that, have an education also.
Can I raise a question, please?
Yes, sir. Please.
Is it over with him, Ms. Vishweshwar? So,
Yeah. Carry on, sir.
See, ma'am, I want to know only one thing. See, we receive the application, right? We receive the application from the different bidders. You are able to hear me?
Yes, I am able to hear you.
So we say that this fellow is eligible, this fellow is not ineligible, as per section 29A, right? So the COC has to be informed about both what is the stock of the entire application received? What was rejected? What was accepted? Should we inform everything to the COC?
Yes.
On what ground we rejected? Also, we have to inform. And also, we have to record it in writing.
Absolutely, you are right. And sir, there is a duty cast by IBC on resolution professionals, liquidators, along with them. COC also, there is a duty that COC need to assess Section 29A diligence. That
Okay.
is what is happening in all the processes is bankers, especially COC members, are very, very particular about Section 29A diligence. Double check they are doing. They are also asking us to appoint a third party for assessing Section 29A, as well as they are taking compliance certificate from RP before voting on the resolution plan. They are asking RP to give compliance on Section 29A. That means we have to assess.
So big responsibility.
Yes, responsibility is on us, and even NCLT is asking us only whether you have ascertained the SRA is a Section 29A compliant. We are giving declaration in Form H. We are signing complied. So this is all issues, sir. If you see the Bhushan Steel case, the Supreme Court has passed an order, in that where they are clear, specifically mentioned that RP has not done Section 29A diligence. There are some procedural related things which are not complied. That is why they have referred after approving the resolution plan, after 6 years, they are referred for liquidation.
COC is totally relying on the IPs only. They don't take any responsibility as regard to 29A compliance.
They are not taking any responsibility. They are making RP responsible for this. They are taking reports from the third party. They ask RP to take. Also, they are taking compliance report from RP.
Even if third party is going to give some kind of a comfort for assessing whether a person is eligible or ineligible, to what extent it will protect the RP?
No, it will not protect. It is only for our
It is
satisfaction.
only a comfort, that's all.
Only comfort.
It's only an additional info, that's all.
Correct, sir.
See, ultimately, the responsibility is only on the RP.
Right, sir. See, I see two kinds of things in IBC, sir. One is Section 29A, the other one is PUFE application. See, when Section 29A, you are taking help from third party, but however, COC and NCLTs are asking, RP, are you comfortable and are you giving compliance certificate that the SRA is a Section 29A compliant? And even when we are assessing the preferential undervalued fraudulent extortionate transaction, avoidance transactions, we are filing application. There we are taking forensic audit reports, but however, COC, NCLT will not rely on that reports. They will only, the code also casts duty on RP and liquidator that forming an opinion, determining on the transactions and filing the application is completely prerogative of RP or liquidator. COC will not come into picture. So even forensic audit.
Yes, perfect transactions also, it is the responsibility of the RP or liquidator.
Correct.
They can take the help of a transaction auditor or a forensic auditor, but whatever report they are giving, I think this IP has to scrutinize the report beyond the things.
Right, sir. You are right.
I think at the end of the session, I have to rethink whether to continue.
No need to rethink, sir. People are there to support.
There are
But still, that is not supporting me. No, I have to say yes.
One thing, if I say there are so many cases which are not having perfect transaction issues or 29A issues also. People will
So
also be.
we have to pray God that we should get a case like that. Yes, I'm sorry. You can carry on.
Mostly people are there to support you, sir. We have handled close to 40 assignments in across Hyderabad and Bangalore. If you have great team, it's really challenging role, sir. IP.
So which
Independently, you cannot handle, sir. That is why we are seeing now a lot of IPs are forming IPs. See,
Okay.
not only IBC, if you have seen recently, RBI issued a paper where in stressed assets they want to give role to insolvency professionals and IPs for as a resolution managers.
So eventually everything will go to IPA, IPE.
Insolvency professional entity slowly, sir. Slowly,
It will go to them and IP will serve them.
sir, you can form your IP along with your.
That is involving lot of capital. Who will do it?
You are from which place, sir?
I am from Chennai. Very conservative fellow. It calls for a very huge investment in capital and doubt. And we have to bring people from different part of country. It's difficult.
But individually, it is very difficult, I think.
Very difficult.
You have to
Sir,
take the help of so many people.
sir, I don't have any assignment with me now. I'm
Mm.
telling you, it's 4 years since I have completed, but what to do? See, I have enrolled myself and I should comply with CP, I have given undertaking that I will comply. Let me be very open. I don't have any assignment.
So any more queries, sir? Questions from participants? So basically, when you do the diligence, you have to do this 4-level diligence of the persons who are submitting the expression of interest. First layer, second layer, third layer, fourth layer. So usually for persons, they will give declaration. They will give declaration along with the details of the related party and all the PAN numbers. And for companies, it is little, you have to go detailedly with the reports, probe reports, which are available online. Then assessing the connected persons, related persons is little difficult in case of corporates, but however, market tools are available for this. So when we go,
Are we taking any letter from the corporate data or directors or some people like that, asking them to furnish their list of the relatives, their sons, daughters, and all these things? Are we taking?
we have a format. One is we are taking affidavit. The other one is when we are issuing detailed EOI and also the auction document. There we are giving formats, sir. In that formats, we are asking them to give the details.
Achha, it is devised by you, not by.
Yes, yes. It is devised by the respective RP or
Because we are also supposed to give some disclosures. Now, unless we know the names of the people with whom we are dealing, we will not be able to give any disclosures also.
correct.
Disclose.
Correct, sir. And one more checkpoint is when we go to the person's name who is supports an individually submitting, he will give the details where all he is director. So what we can do is we can go to the MCA site and also find out where all he is director. And we he is director, that company's directors are also connected persons to him.
Yeah.
Not only related persons, but connected persons also. The ineligibility applies to the connected persons also.
I think it has to be restricted to 1 or 2 layers. Otherwise, a stage will come where there will not be any SRA to submit plans.
Sir, but again, what happens through connected persons, they will submit, sir, the promoters. Usually, all promoters, they will have connected persons, connected companies. So, through related or shell companies, they will come and submit the plan. So this connected persons, if we see, it is beyond blood relations. So not only blood relatives like family ties or formal relations, also they will consider. We have to consider while in the disqualification. See, usually what they'll do is they'll try to go through some routes like they'll try to bid through the companies where their related parties are also directors. Suppose if we'll give one example, if a promoter is disqualified under section 29A, but however, he funds a bid by a independent third party and
Okay.
an underlying arrangement, that party could be disqualified as connected person acting in concert.
No, how will you know that? See, we
But
won't.
we should know it. No?
Unless otherwise you do a thorough examination of his books of accounts, how will we know that he is funded?
See, basically what we are doing is, sir, we go and take online tool help. We'll go into the probe and we'll try to find out in case if that and sometimes even the Google searches also will help. Some big companies are submitting their joint venture agreements or some mostly see in probe and all, if you go, you'll get all the complete director where he is a director, all the related companies where he is director, also the court cases, the where the court cases are pending. It's again through market search only. We will get the details. The system will.
Funding from a different place to the company is difficult to actually analyze and find out. See, even probe also. See, probe is not the ultimate. Suppose I go and tell the NCLT that I have used a tool called probe. Will they say yes, you have done your due diligence?
No.
If it is found to be untrue, they will
No.
not. They will hang us.
Here, what I am trying to say is,
So somewhere, I think IBB also should say that this is what is the line where the IP's responsibility stops. You can't go beyond.
see that fourth layer is again little critical, sir, to
Very
assess.
critical, it's very difficult, very difficult. I
Till
saw your slide and I understood that it's very difficult to find out like that. Anyway, it's challenge in front of us.
yeah. See, the,
We fund with a good heart, but end up with doing all these things, what to do.
see, we can see various cases how things were dealt. In one of our known IP's case, what has happened? Wife has submitted the expression of interest for the company of husband. So what has happened here? They filed a divorce petition. So they filed a divorce petition and wife has submitted. Then when NCLT went and disqualified, they went to NCLAT saying that it is a business relation and not a personal relation. I'll try to share that
Because
case.
husband, wife divorced, right?
They have applied for divorce, not yet divorced. So they said it is a business relationship, no relationship. It is only a formal relationship, no family ties nor blood relation. So they tried to bring this out of section 29A and they succeeded at NCLAT.
No problem, madam. See, we call them, you are not eligible. They go to NCLAT and they succeed. We are out of it. We are not going to be hanged. Suppose, so tomorrow it is a real case of the conflict of interest where we omitted by mistake, by oversight, then it is a trouble.
But sir, more or less what happens is we have one small checkpoint, sir, somewhere. See, PRAs who submit the plan, we issue the prospective resolution applicant list. We can work out certain things a little carefully. practically what happens, you issue a prospective resolution applicant list in CIRP. When you issue that to all the other prospective resolution applicants, who is a competitor, he after issuing prospective resolution applicant
He
list,
himself will come and tell you that this fellow is conflict of interest.
you will give 5 days time, no? You will give 5 days time to give any objections to you, to include him in final list of resolution applicants. So what happens to create some kind of issue, or he want the other person? The other person will know lot of commercial dealings. They are there in the market.
Yeah.
Try to come and tell you. So this is biggest section 29A tool for us. This is not the IBC. This is just I'm telling out of.
I'm telling you, I understood that. It's only example. Yeah, I understood.
So in one of our case where we had a tender for almost 125 crores, 125 acres land in Telangana, Hyderabad outskirts. Very excellent lucrative place where 3 iron ore steel company was bidding. So when one guy has submitted, the other guy has come and said that he is ineligible because he used to supply coal to that company, corporate debtor. He is related. So like that, people will come and also give some clues. But however, the role again, the duty is on us to go to use whatever tools available for ascertaining the diligence.
Otherwise, there is a gross negligence. Do you feel that in these cases, the NCLT will squarely blame the RB? Suppose there is a gross negligence, he has not done his diligence properly. And it's a case of a gross negligence on the part of the RP to bring out the conflict of interest. Beyond a point, the RP is also, his hands are also tied. Okay.
Sir, sometimes in the resolution plans are not approved. They are rejected based on if anything is found out later. It is rejected, and the IBBI will take up the disciplinary action, sir. There are many disciplinary orders. Actually, if you see in ICSI, IIP videos, a lot of disciplinary related to disciplinary proceedings cases we have. The IIP has taken up a lot of webinars on this, and if you see IBBI portal, the majority of non-compliances in timelines or these kind of issues, IBBI has strictly punished IPs. Either passing reprimands or they are suspending for few months. So if we discuss some judicial precedents, then we'll try to understand the intention of this section 29A. RBL Bank versus MBL Infrastructures, where this case provided crucial clarity that disqualification regarding the unpaid guarantees. So here, the unpaid guarantees must have been invoked by the creditor and remain unpaid. So if suppose a person is submitting expression of interest and he has given a guarantee to, say, suppose State Bank of India, and he is submitting resolution plan or he is participating in the auction during liquidation, and SBI has not invoked the guarantee against him, and even if they are invoked, it is paid also, he is eligible, and if it is not invoked also, he is eligible. So simple existence of guarantee or merely default on the principal debt is not the sufficient disqualification. So a person may have given a guarantee. If that is not invoked, he is still eligible to submit the resolution plan.
It is as good as a regular relation, isn't it?
It's like
Not
a
But if the guarantee is defaulted and is not paid, guarantee is invoked and not paid in time, and it has become NPA, then he is not eligible.
right, sir. So here we have to take one important aspect which we need to check here is invocation of guarantee is again, if we see section 29A, that is invocation of guarantee by any creditor. If we see the word, it is creditor, not only financial creditor. For any other guarantees also, the guarantees have to be invoked. Then we see Ruchi Soya Industries, where the endorsement of resolution plan was contested due to allegations that the top bidder was ineligible under section 29A. Even Ruchi Soya, if we see the section 29A, some ineligible, the one of the L1, L2 who was contesting, the top bidder was ineligible and the process was again called for because of section 29A non-compliance. Even in JR Agro Industries, a resolution applicant appealed against the decision of RP to reject their plan. Here, JR Agro was disqualified, specifically citing E and J due to ownership in 43% shares in JR Organics. This is again an associate company. Associate company who was holding 43% shares. Through them, they submitted the plan. So again, NCLAT held that the disqualification under clause C, E and J, that is connected person. What is section C, E and J? I'll just read out the clauses under which regarding this associate company they were disqualified, because this is important.
That is you.
So section 29A, the RP has argued that E and J, they are ineligible. If we see E, who is disqualified to act as director under the Companies Act, and also J, if you come J, can you go down? Has a connected
person, not eligible under clause A to I.
In one of the company, the director was disqualified for non-filing of their financials. Also, they are connected person. So he has disqualified them under E and J. But however, NCLAT has added one more. That is, they have added that he is ineligible under C also. C is at the time of submission of resolution plan, has an account or an account of corporate debtor under the management or control of the person whom such person is a promoter or classified as an NPA in accordance with RBI guidelines, and the period of 1 year is not lapsed. So here they had one of the group company who was also NPA. So all this maybe while hearing one of the points which regarding the NPA point also added. So that is why NCLAT has added J also, and the company was disqualified to be a resolution applicant. So in one of the case, Gaurav Jain Jagriti Plastics, here they clarified the connected persons, holding that simply being a director in another company that had an NPA would not automatically disqualify unless there was evidence of control of association with the NPA causing entity. So here, one more important point which they clarified is not only connected person, but this is again fourth layer, where they are talking about the fourth layer. Not only NPA causing entity, but they should also have connected person who is controlling. So connected person means, again, go back to the definition under Companies Act. Who has connected person who is also controlling the corporate, the prospective resolution applicant. So sometimes in rare exceptions, the courts are giving degree of flexibility, but most of the time section 29A is very strictly followed. No flexibility will be allowed, except very rarely some NCLTs have given a fair flexible options in case of these kind of NPAs and the controlling companies or wherever they have these connected persons. But again, it is on factual basis. So when we come to the critical cases under section 29A, we have to discuss Swiss Ribbons, ArcelorMittal and recent Bhushan Steel case. And also one or two cases we'll discuss in detail. Can we have 5 minutes break, sir?
Yeah, yeah.
We'll have 5 minutes break and we'll come back and we'll discuss the case laws.
Sure,
Yes,
madam.
madam. Yes, madam. Yes.
చెప్పు. డి ఆ, ఆ. నువ్వు ఇంక ముందరికి వెళ్ళిపో, నెక్స్ట్ స్క్రీన్కి వెళ్ళిపో. ఇది ఎక్కడుంది? ఇది ఆన్లైన్ అప్లికేషనా? పేమెంట్ ముందరికి వెళ్ళట్లేదా? కానీ నువ్వు కాదు కదా.
20 minutes now. It's not over yet.
Yeah, sorry, I just got onto a call for 5 more minutes. So we'll discuss about a few case laws where the section 29A is clearly the principles of section 29A is dealt by the Supreme Court. So if we see the latest one, that is Bhushan Steel, but first we'll cover ArcelorMittal versus Satish Kumar Gupta, where the main principle of section 29A, which is designed to identify individuals who genuinely exerted control either individually or collaboration with others, where ArcelorMittal and New Metal were ineligible to participate in the resolution process. Here, the ArcelorMittal's proposal was rejected due to association with a company whose account had become an NPA. Even including New Metal's plan also was declined because one of its shareholders had a tie to a promoter whose account was categorized as NPA. So this is very important ruling by Supreme Court where the importance and adherence of section 29A eligibility criteria for resolution applicant in insolvency proceedings is important. So even though very good bids were submitted, even they were very big companies, but they had some kind of association with the corporate, with the company. Earlier, they would have dealt with the corporate debtor. They would have been, some of the instances I'm just explaining, they would have been suppliers or there could have been some joint venture agreements. So all these kind of associations we need to see. In this case, New Metal had a shareholder who had again related to the promoter who was categorized, whose account was categorized as NPA. And also ArcelorMittal, they had an association with one more company. That company was declared as NPA. But however, while submitting the resolution plan, in case the company repays the entire debt and they are come out of the NPA, then they are eligible to submit the resolution plan. So one recent case in case of Haribabu Tota regarding the MSME. See, when we see section 240A, which has specifically bought for the MSMEs exemption of section 29A, once again, I'm just clarifying to all of you that section 29A MSME applicability is only for two sections, two subsections are exempted for MSMEs, that is subclauses, that is C and H are exempted for MSMEs. So section 240A MSME, this case on November 23, here in this matter was before NCLT Hyderabad, then it went to NCLAT, then it went to Supreme Court regarding the section 240A and 29A, where the MSME promoter went and applied for a MSME certificate during the CARP process. So what are your views? Whether he is eligible or not eligible? So in this case, what has happened is the appeal went to NCLAT on June 23, where NCLAT has dismissed the resolution plan submitted because the promoter are prohibited by submitting the resolution plan since the company had no MSME when CARP commenced. So they said that MSME certificate was obtained after at the time of submission of resolution plan. So NCLAT has again taken reference of one more case, Digambar Anandrao Pingle versus Shrikant Madanlal Zovar, where they are not allowed the promoters to file the resolution plan seeking MSME relief and applying for MSME certificate during CIRP process. But however, Supreme Court in this case interpreted the 240A non-obstante clause. In this case, the background, we have to see the background of BLRC committee also. Here the report stresses the fact that MSMEs are the bedrock of Indian economy and they have to be given certain privileges. And for the stability in insolvency and restructuring regime, this is very crucial aspect, and the report stressed on the judgment main aim to resolve the financial problem of the CD rather than to push into the liquidation. See, when we see the BLRC committee report, the committee stresses more on the regarding the MSMEs, they'll stress more on the resolution and revival of the company rather than going into the liquidation. So in this case, they have allowed for the, they have allowed that the MSME promoter taking the MSME certificate during CRP process and submit the plan. So one more is regarding the Monet Ispat case, where the related party clause has created some confusion here. The only bidder in the company was AION Capital, and JSW Consortium was also one of the PRA bidder here. And JSW Steel promoter Sajjan Jindal is the brother-in-law of Monet Ispat. That is, he is founder and also promoter of and also related to the Jindal group. So the lenders here, there was confusion on the related party and the lenders took legal opinion. COC took legal opinion before finalizing the bid of the related party consortium. One of the company is brother-in-law of the consortium related connected party. So here an immature provision which stops the highest bidder from receiving the company and paying the greatest return just because of the ineligibility. So what has happened here? The connected party, the COC took legal opinion, although not connected at first, second, third layer. But if we see again, the fourth layer, it says that again it is linked to first, second, third layer. So if we see the fourth layer, that connected company, again relative. So here, even if you are paying highest bid also, just because you are paying highest bid, you cannot claim eligibility. So if you are ineligible under section 29A, even you are the highest bidder, you cannot claim for you cannot claim that you are not.
Yes, ma'am.
Qualified. Hello. Yes, ma'am. Anjali ma'am, you are saying something?
Are you saying something?
No, I am just taking presentation, ma'am.
Okay, ma'am.
So here the judgment also touched upon doctrine of piercing the corporate veil in the context of insolvency proceedings. Here the court also addressed certain issues relating to the timelines of section 12 IBC. Not only section 29, there were other issues related to the IBC while exercising the powers under 142, the Supreme Court has interpreted. So in order to complete justice and allow both resolution applicants to pay off the NPAs of their related corporate debtors within a period of 2 weeks. So what has happened here? Their related parties had an NPA. Their related parties had an NPA and they were not qualified to submit the expression of interest. So what they suggested is they asked for some time to repay that, pay off the NPA and get the qualification. Then after repayment, after payment of the after they have come out of this NPA disqualification, they were allowed to submit they were qualified to submit the plan. Here, the main disqualification should be on the date of submission of the resolution plan, the disqualification should apply. So as per the IBC laws, the court also granted additional opportunity to the resolution applicants to submit fresh bids, acknowledging that section 29A had been let down for the first time in this judgment. So here, the Supreme Court has given a special time, because first time the section 29A was coming for application. So they have given some time to the PRS, and additional opportunity was given to submit the fresh bids. So when we see one more important, very recent judgment of Kalyani Transco versus Bhushan Steel, non-disclosure of joint venture by JSW with Bhushan Steel, who is a related party, and the resolution applicant, the resolution professional, without doing a proper diligence of section 29A, they have allowed JSW to bid for BSPL, because earlier, now Supreme Court has it has come to the notice and submission based on various submissions by parties, that there was a joint venture by JSW with BSPL, which was disqualified under section 29A. So here Supreme Court has clearly laid down that it is the mandatory duty. So section 29A due diligence is a mandatory duty of RP. The RP has to verify the ineligibility criteria of resolution applicant. It is again the duty under section 31. Section 30 subsection 1, which requires the resolution applicants to submit an affidavit confirming their eligibility, and section 30 subsection 4 also casts an obligation on the resolution professional to verify the eligibility of RA. Although the affidavit submitted by resolution applicant gives us cushion, but again the responsibility and the duty which is mandatorily cast on RP to verify the eligibility is again on RP. So RP has to confirm whether RA confirms and is eligible and does not contravene the provisions of section 29A, and also before placing the plan for approval. See, what is the point of doing the diligence, and is on receipt of the resolution plan, on submission of EOI, you will do a primary diligence. Then again, after submission of resolution plan, you have to ascertain whether he is eligible. If he is ineligible, you are not supposed to put the plan before COC for voting and their approval. So feasibility, the COC will again do a feasibility and viability of the resolution plan. In that, they will also see whether the plan is feasible, viable financially, not only financially, but also on the implementation aspect and also compliance aspect. Especially bankers are very, very diligent in compliance aspect, because they have their own reporting, and they have also audits, concurrent audit, quarterly audits, yearly audits, CAG audits. All these audits, they are very, very particular, and they have a separate wing where the CARP, IBC accounts are audited, where they meticulously go through all these compliances. And COC, especially in COC meetings, they will advise RP to make a note in the meetings regarding the ascertainment of the diligence under section 29A. See, these are all very, very important. As an RP, Supreme Court has come against RP for this diligence of section 29A. So when the section 29A diligence is happening, if anything comes to the knowledge of RP and COC, even if it has reached an advanced stage, even the resolution plan stage or the liquidation stages have reached an advanced stage also, it is better that the same has to be either RP and COC has to make a note in and take it to the NCLT, or better they disqualify them and take this process forward. Either COC will take a decision to go once again for bid process issue of Form G, or they may go for liquidation. So if it has to be litigated, if the party is litigating, they will go to NCLT, or even if there is any issue, RP and COC can go and knock the doors of NCLT for clarification. But again, RP should not keep it himself, or the diligence, whatever facts come to the notice of RP, everything has to be minutized and he has to protect himself from any future proceedings, disciplinary proceedings against the RP. So here they have clearly laid down in Bhushan Steel that at the time of submission of approved plans before the adjudicating authority, before placing the COC, they have to provide a compliance certificate. In this case, if you see, with due respect to Supreme Court is coming out that RP has not provided compliance certificate for section 29A. But we need to go back and see whether the compliance certificate requirement was there at the time 6 years back. So all this will be verified now. If IBBI takes up this case against RP, they will verify. RP will have to justify that this compliance certificate was not applicable. So ensuring every compliance of code regulation, if there are no specific regulations also, RP has to ensure that he is properly minutizing, properly communicating to the COC. In case if there is any point of law or fact where he need clarification, it is better that we go back to COC and advise them to that we will seek clarification from NCLT. See, out of section 29A, I just want to clarify here one point. In one of our case, there was an attachment of the assets of corporate debtor by enforcement directorate. That is, ED has attached our properties and the company was under CIRP. And we have taken some of the properties on lease from various lessors, like one of the state government of Andhra Pradesh, we have taken a huge premises where the corporate debtor assets were fixed, like furniture fixtures, tables, then projectors. It was very beautifully designed interiors were done by the corporate debtor. And but whereas the property belongs to the AP, that AP government. So what we thought, if we are removing all the furniture and fixtures during CIRP, because enforcement directorate has passed an order stating that status quo has to be maintained on that assets. We cannot touch the assets. So if we want to remove the assets from that place, we cannot remove. 5 crores worth assets we will fetch some 20 lakhs only if we sell all those. And if we are not removing, the lessor was asking us to vacate. Now in this situation, our hands were tied because ED attachment was there. What we did, I advised our COC that we will seek NCLT directions, that we will give our property, that interiors, on lease. Suppose the AP government is giving that building on lease, whatever properties, that interiors done by corporate debtor, that lease they should add and they should pay the corporate debtor so that the assets is preserved. Since ED was involved, we took clarification by an NCLT order and we proceeded. So likewise, even in any such cases, if any ineligibility aspect or if there is any issue, NCLT directions can be taken. to protect the RP's interest. So Supreme Court here in this case, Kalyani Transco versus Bhushan Steel, they have observed that the ineligibility of resolution applicant to submit the resolution plan goes to the root of the matter. That is, resolution professional has to verify and certify the mandatory affidavit filed by RA. So again, even if there is a mandatory affidavit submitted by RA, it is the duty of RP to undertake a scrutiny of the eligibility prior to presenting the plan before the COC. So failure to discharge the duty will result in risk of ineligible applicants granting access to CIRP, which is again losing the sanctity of the process and violating the laws. So here they have clearly mentioned that RP cannot rely on the affidavit submitted. He must exercise due diligence in verifying the compliance with the statutory mandates. So here what the Supreme Court has set aside the resolution plan and directed liquidation after almost 6 years. The plan was under implementation just because there were significant gaps in conducting the CIRP process, like not meeting the CRP timelines within statutory fixed timelines, deficiency in eligibility criteria verification of Section 29A, then irregularities in plan implementation. Then one more is judicial overreach of NCLT NCLAT. That means NCLT NCLATs, whatever is their jurisdiction, they have decided and given orders overreaching their powers granted under IBC. So we have gone through ArcelorMittal, Bhushan Steel, and some other precedents from Supreme Court, and also few NCLT cases in this regard. One very important case law is regarding the Swiss Ribbons case in Section 29A. Here, many promoters who were getting the disqualification of Section 29A initially, when the Section 29A amendment has come, many promoters went and filed saying that this Section 29A is violative of their fundamental rights and it is unconstitutional. So here, Supreme Court has upheld the constitutional validity of Section 29A, saying that the defaulter's paradise is lost by promulgating the IBC code. Now it is in place and the economy's rightful position has been regained. Hence, because of this and because of the comments from BLRC on the not allowing the persons who is responsible for stress of the company, they cannot come back through a back door and regain the control of the stressed corporate debtor. Hence, in Swiss Ribbons case, Supreme Court held that all the petitions challenging the validity of Section 29A is disposed, upholding the Section 29A. Then one more recent case is IDBI Bank versus Amazon Transportation, where reasonable opportunity should be given to PRA who is disqualified. This is very important again. See, when you are disqualifying a person, again, principles of natural justice and reasonable opportunity of being heard is again upheld in by NCLT in IDBI case, where the PRA was disqualified, but again court has held that opportunity should be given to that party and asking him why he cannot be disqualified. So without hearing, if you disqualify, that is not allowed. So again, if we see Section 240A, which gives here which gives an exception to the MSMEs for ineligibility. One important recent development was pre-pack insolvency. So here, notwithstanding anything contained in 29A, shall not apply to the resolution applicants in respect of CARP of any MSME or under pre-pack insolvency. Even for pre-pack, this is not applicable. Again, same point, section 29.
Ma'am, sorry, the previous slide, please. My mic was switched off, so you didn't hear my question. The previous slide, please. No, not that one, the other one. You said MSME, you said
240A.
notwithstanding anything contrary to so and so, shall not apply to the resolution applicant in respect of corporate insolvency resolution process.
Of any
Of
MS.
any, so if the MSME, they can the promoter himself can participate. Am I right?
Yes, you are right. Promoter can participate, but again for him, clause number C and H is applicable. C and H only not applicable. All other again applicable to him. If he is a willful defaulter, he cannot apply. If he is undischarged insolvent, he cannot apply. C.
Only NPA borrower or guarantor.
Yes, sir. Yes. Only these two are applicable to MSME. That means if he was an NPA or 1 year not elapsed, this
But
clause.
he has corrected. NPA question he has corrected. He should have corrected, right?
Yes, sir. He would have paid. If he pays, then he is eligible.
That is even otherwise also, not only for MSME.
Correct.
No,
But
for otherwise, for other than MSME, there is a some kind of a cooling period. Then only they become eligible. Here, MSME, the moment, am I right, madam?
Cooling period, sir, because.
Cooling period meaning what? Is that suppose I should have paid it 1 year back. After 1 year only, I become eligible. Or 2 years. You said something, 2 years.
No, sir. It is 2 years for imprisonment. Offenses punishable with imprisonment 2 years. That is.
Suppose if I am a big corporate and I am MPA, I have corrected the position by making the entire payment. I am eligible for other.
The meaning is that as long as
some other CARP, I am eligible for applicant, right?
as long as the borrower's account is a substandard account, I think it is permissible if it is paid. If it is more than 1 year old, that means it becomes a doubtful asset. It is not possible.
Sir, here, if you see the clause, it says you are classified as NPA for more than 1 year and you not repaid the overdue amounts. And you see in ArcelorMittal New Metal, when this was applied on the first case, they have given some time to the resolution applicants to get the
special permission.
So immediately on payment, once they were come out of NPA, immediately they were eligible to submit the plan.
That's what I'm telling. Okay.
Madam, one more thing, suppose the guarantor is there, say for example, XYZ is giving a guarantee to ABC and ABC is not permitted to be the SRA. Suppose if the guarantee is not invoked on XYZ, XYZ can become an SRA.
Yes, sir. See,
because he is not invoked.
See, if only existence of bank guarantee will not disqualify. It has to be invoked and unpaid. If bank is invoking and the guarantor is not paying, then he is ineligible.
No, he is ineligible. Yes. Suppose if the guarantee is not invoked, even if CARP is initiated, then he can be a part of SRA.
Yes. Yes.
And we have to see somebody is giving a bank guarantee for someone. In what capacity is giving the bank guarantee? Also, we have to look into. Suppose if he is otherwise related. If he is otherwise related, see, no one is going to give bank guarantee just like that.
Yeah, even that, then again that layers, he comes in.
Then you have to go to the layer, right? You are right. Then we have to go through the layer, whether
Yes,
they go into, they fall into that.
correct, correct. See, apart from this routine, whatever applicable under section 29A, then again that 4 layers, sir, you have to see. This all applicable to first layer also, second layer also, third layer also, fourth layer also.
Fourth layer also.
And even to the connected persons, related persons, again persons acting in concert with above also.
Associate also.
Yes, yes, associate company, connected, subsidiary, associate company, joint venture agreement, joint venture also. In Bhushan still there was a joint venture agreement. JSW group company with Bhushan earlier. So basically section 29A is diligence and also your market based small research, whatever you can do.
Common sense.
Then
We have to apply common sense also. Lot of common sense also.
I
market.
think
Connect the
we can
dotted
use
lines.
ChatGPT also for ascertaining things.
Yes, 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 yes. That will be useful. That will be useful.
Judicial precedents also will have some principles, sir, which we have to follow. Like nobody will think that husband and wife is not related. But again, you have to see it is again fact based. See, if you see it is again fact based.
Whether really is husband or not.
Ma'am, let me tell you something. There is every possibility only for this reason they would have applied for divorce. Am I right?
Maybe, ma'am. But again, if you see what
Hmm.
was station is, they said they have applied for divorce and it was pending. Then they said it is a business relation.
Okay. Then if that is the case, then every relationship is like that. Of course, you can't go for a divorce in case of a brother or a sister.
Yes. See, if you see section 5, subsection 24, the related parties definition under IBC is exhaustive, ma'am.
No,
So I think the time may come that ex-wife can also be included as a related party.
these are wise.
So again, if you see the definition of resolution applicant, here it means a person who individually or jointly with any other person submits a resolution plan to the RP. So even individually or jointly, as during my presentation I mentioned, you have to see the eligibility of all the applicants, like person A and B are submitting, A and B. A's relatives, A's connected persons, that 4 layers, B, again B. If A is director in one company, then again that director, that company's directors related. All those connected. So here, in one case in Namdev Hindu Rao Patil versus Virendra Kumar Jain, appellant was declared willful defaulter in 21 July and October 21 by IDBI Bank, whereas the appellant submitted resolution plan in 2022. So as per section 29A, on the date of submission of resolution plan, the appellant was clearly ineligible to submit the resolution plan as per 29A-B. If you see 29A-B, it is willful defaulter. So it is only just a declaration as willful defaulter is sufficient in the RBI, as per the RBI guidelines. Any more case laws we have missed? So when you see the basically the conclusion and future outlook of this is it has to be balanced, giving competing objectives like it is creditor protection. Mainly the balance between the creditors protection, ensuring maximum recovery for lenders. When a person comes through section 29A, they try to get a clean slate without much recovery to creditors. So if a person comes from same who is responsible for the stress, he will not think of any business revival. He will only try to come without any viable business proposition. He will try to just enter with getting a clean sheet for the previous liabilities. Again, he may try to come back again, continue the same story. So preventing abuse, it is only closing the unscrupulous individuals who are responsible for this stress and also to close the loopholes in the competing process. Again, this is legal fairness principle where the consequences providing clarity of who is ineligible. So this is again basic principles for balancing the competing objective of 29A. So basically, what is the challenge for section 29A? If anyone can just tell what are the challenges for 29A?
Getting through that layer 1, layer 2 itself is a big challenge. Cracking layer 1, layer 2, layer 3, layer 4 itself is a big challenge in front of us. One.
You are right. It is.
You can give it to the person who are doing it. At times, when we ask for an affidavit, they refuse to give. They will be saying, I will send you in 5 days, 10 days, 15 days. The days will go up, then you will not get an affidavit from the person who submitted the plan.
But see, as per section 34, if we were discussing in the presentation, it is mandatory along with the resolution plan application to NCLT that you should submit this affidavit.
Affidavit.
This affidavit is not submitted, NCLT will not approve the resolution plan. And even we cannot proceed for putting up this plan for voting before COC. This is mandatory requirement. When you see, when RP is submitting the diligence report to the COC before the approval of the plan, there are mandatory contents given under regulation. So those all we need to tick mark. So while ticking, there is an affidavit also. Affidavit submitted by PRA while submitting the plan. If that affidavit is not there, you cannot take this plan forward. So that is important. So we don't have proper accurate filters to bring out bad, fraudulent, willful defaulters or related parties. So what we can do is continuous refinement of long-term effective tools have to be devised, and also the declarations from the prospective resolution applicants have to be stringently taken up. See, even what we can do is regarding the associate companies, connected persons, usually see there are 1 or 2 tools where if you put the name of the person, PAN number, because you see in MCA, the DIN and PAN are interlinked. So if you put the person's PAN number or DIN number in that search tools, you will get wherever he is related as a director or in LLP. And even this probe or the tools, you will get the case details. So some of the effective measures are available, but as we have been discussing with sir, sorry, your name, sir, we are discussing. Vishweshwar, sir, and
Yeah. Yes, sir. Yes, madam.
your screen is showing as K. Rama, sir.
Hey, Ramakrishnan, ma'am, I don't know. See, last time it gave some my wife's name. So they didn't give me certificate. This time at least it is giving K. Rama. I'm happy about it.
So We have been discussing, as you rightly pointed out, the main issue is finding out the fourth layer. First layer, related party, we can take declaration. Second layer also, connected persons, maybe through market tools we can find out. Then again, that fourth layer, it is little difficult. As you rightly said, maybe IPs, as an IP or liquidator, we can devise a certain format where we can take the details from the person who is submitting the expression of interest. So here, what as a role of RP and liquidator, the conducting due diligence on applicants, section 29A, due diligence, and we have to use public database like RBI, CIBIL, MCA 21, IBBI, and verify the connected persons, related parties like declarations or affidavit. Then as a role of RP, we need to file in this form H. So we have to ensure that we comply all the CRP regulations. In case if RP has any doubts about the persons, most of the times bankers will be dealing with them. So we can seek clarification from COC or NCLT whenever necessary on the about the party's identity or related parties.
The list of defaulters that is actually available with the RBI, is it a public document? Can we go ahead, go and download it?
Yes, sir, it is available, sir. So again, we say that section 29A is a gatekeeping provision, so that only credible resolution applicants come and participate in the process. Otherwise, the object of IBC is
Defeated.
and RPs are the liquidators are the key functionaries. We are the key functionaries. We have to ensure that 29A is effectively implemented. So basically, I just touched upon how section 29A has to be interpreted and how, as a practically, what are the tools available to us and how we have to do the diligence and what are the available market sources for us to review this and how judiciary has interpreted section 29A. All this we have just briefly dealt. So in our cases, what we were doing is, usually when the person submits the expression of interest, we go and check on the MCA portal. Before the issue of prospect to resolution applicants, the first PRA provisional list, we do a diligence on MCA portal and we will see whether any related parties are related to corporate data or any of them are disqualified. That basic diligence we will do. And we have time of 30 days wherein we issue the VDR, we issue the RFRP, and we issue the diligence time to the PRS to submit their plan. So that time we have sufficient time. So what we will do is we'll try to take the help from market tools will be used, and we take help. There are some 3-4 good 29-year diligence companies who do market search through various online platforms, and they get a very detailed report, sir. Sometimes we have done for one very big company that Excel sheet ran into 50-60 pages. But one good thing is they throw the report wherever some red flags are there, they give us a summary report. So again, what happens if they throw some red flags in that online platforms, that red flag itself, we will again do a further diligence. So most times that filters come, but as you rightly said, Ramakrishna sir, it is little difficult for that fourth layer, like some joint ventures and all. Only it is accessible at board level, at company level. So we will not know some joint ventures, except Some very big companies, if information is available on online platforms. So usually these market professionals who are available for giving this 29-year diligence, they also do complete news portal search. Like sometimes if it is a listed company or big company, some news will come. Through that link also, if any red flag, any news is there, important news, it will flag into that reports. So basically overall, I can rate 70 to 80% we can get the report.
Information.
From that 20% is again lacune.
We have to collate and do some kind of a logical analysis.
Yes, yes.
One small query, madam. May I?
Yes, sir.
Madam, can you share this PPT?
Yes, sir. We will share it, sir. We will share it with ICSI IIP. They will share it with you, sir.
Okay, thank you.
Thank you, sir. Any more questions we can take up?
Thank you very much, madam. Actually, it's a very, you are talking about some summary level. Actually, it's a detailed presentation only, I should say. It's almost 50 slides. You have taken us through the entire 29A. So it's a very good broad outlook.
Thank you,
Thank
sir.
you. Thank you.
Some more judgments, but since paucity of time, we couldn't cover. Thank you. If you have any queries in section 29A and all, you can email me.
Yeah, sure. Definitely.
We will help you out.
Oh, yes.
Thank you, madam. Thank you. The session was.
Thank you very much.
Thank you, everyone. Thank you. Bye.
Thank you very much, ma'am, for such a nice and interactive session. Thank you very much. The session was very knowledgeable and we learned many new things from you. Ma'am, please share the PPT also.
Sure, I'll share, ma'am. Thank you. Thank you, ICSI IIP, and thank you all the participants. Thank you very much. It was
Thank you, madam.
of you.